All right, I see that it's 2 o'clock, so I thought we'd begin. Hello, everyone. Good to see you all again, or to see that your names are on this list. My name is Samir Varma. I'm a partner in Thompson Hine's International Trade Practice Group. Welcome to today's SmarTrade Fundamentals webinar on duty drawback opportunities. For those of you who have joined us before, you know that this is the 4th session in a 5-part series focusing on the basics of import regulation and customs compliance. Often in years past, we've done SmarTrade Fundamentals series on all different aspects of cross-border activity. This year, we really did focus on import regulations and customs compliance for obvious reasons, because it's at the forefront of everybody's minds. Today's session will provide an overview of duty drawbacks, the compliance requirements, practical considerations for maximizing refunds, etc. And we'll even share tips for streamlining the claims processes. Before we begin, I do want to address a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees of today's presentation just in the next few days. Just please note, disclaimer, that this presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of myself and Aaron. They represent our views only and not necessarily reflect the opinions of anybody else, the clients, our employers, Thompson Hine, etc. The content should not be taken as advice. The views are expressed for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We'll answer as many questions as we can, both during the presentation and at the end of the webinar. And if we don't get to them, we'll follow up with you after the webinar over email, and we can talk about it that way. CLE will be offered today. Please be sure to complete the verification of attendance survey, which is included in the agenda that can be found in the related content section of the control panel. There's also a direct link there to the attendance verification survey. I will announce the tracking code at the end of the program. Also, in that related content section, you can download a copy of the PowerPoint slides, bios for myself and Aaron, and as well as any other information there. So thanks again for joining us. We'll go ahead and get started. I am joined today by my colleague, Aaron Mandelbaum. Aaron is an associate in Thompson Hine's International Trade Group with me. He's a whiz at the duty drawback stuff and really anything related to imports, exports, economic sanctions, you name it. Aaron's your guy. So Aaron's going to take the lead on doing the presentation today, and we'll go ahead and get started. Let me advance the slides. There's the two of us. I'm glad to see that my picture's been updated since the last webinar that we did, which is a good thing. So again, just real quick to go over the agenda. We're going to start with talking about duty drawback in general, defining what duty drawback is, looking at how it can help mitigate some of the tariff liabilities. We'll go through 2 notable drawback quirks. We'll then run through the types of drawback. We categorize them in these sort of 3 categories: rejected merchandise, unused merchandise, manufacturing. We'll run through some of the compliance requirements, including record keeping, filing a drawback claim, and protest, and then go over some of the penalty considerations. Before we started, I wanted to just put drawback in context. As I mentioned before, this is the 4th in a series of webinars that we're doing on this entire idea of imports, but mainly it's really about tariff mitigation. When we look at tariff mitigation strategies, and especially in the era now where tariffs are becoming a much larger part of our cost structure for many companies, we tend to look at them in a lot of different ways. And these are all the different tools in the toolbox that we have. We think about it in terms of valuation, FTZs, free trade agreements, etc. There's a lot going on here in terms of in the different mitigation strategies that you can employ. In some of our other webinars, we have gone over that in in fair detail. Today, we really are going to focus on duty drawback. But if you have questions about the other aspects of tariff mitigation, feel free to reach out to us. Feel free to reach out to myself or Aaron or really anybody within our international trade group, and we can help you out there. And with that, I'm going to turn it over to Aaron to kick us off a little bit more.
All right. Well, thank you for that introduction. And yes, happy to be here. Happy to talk about duty drawback, or just simply drawback for short. As kind of Samir had referenced earlier, duty drawback is a refund program. And specifically, and this was alluded to in the agenda slide, it is a refund of 99% of the duties, fees, and taxes paid on imported merchandise upon proving its the subsequent exportation or destruction of the same imported merchandise, articles that have been manufactured in the United States using that imported merchandise, or even other merchandise that is allowed to be substituted for the imported merchandise. There's a lot going on here, but hopefully what this does is this definition kind of clarifies just the very rationale undergirding duty drawback, which is simply that it allows American companies to compete in foreign markets without enduring a price disadvantage from paying duties on imported goods. And in fact, this was very much the rationale of when it was first created. Duty drawback is the oldest trade program in the United States. It was actually goes back to 1789 to the Continental Congress. And we can see, not only does it encourage U.S. exports, but it actually has great advantages back home. It incentivizes domestic manufacturing and it creates jobs. So with that being said, let's, you probably are thinking, okay, well, what type of imported merchandise then is perhaps ideal? And the answer to that is kind of, roughly speaking, we kind of categorize them in four major buckets. The first would be non-conforming merchandise. So this might be, for example, goods that were imported, but upon further review, they're actually unfit for sale or for use. Perhaps they fail to meet some sort of quality standards upon importation, leading to their rejection by either the importer or the customer. Second type is pretty straightforward, unutilized merchandise. This is just imported goods that aren't used. They're sitting idly, perhaps in a warehouse. The third would be interchangeable merchandise. So this would be goods that are substitutable with either unused imported merchandise or articles processed from imported material. They've undergone further processing, and that is eligible for drawback as well. And then the fourth category is processed merchandise. And these are goods that have been further processed in the United States that have been made from imported raw materials or intermediate inputs and then sent abroad. What all four of these main categories have in common, though, is that they're easily traceable. They're easily traceable through the import and possibly manufacturing and subsequent export processes. And that's key. As we'll see later on in the presentation, to be eligible for drawback and to ultimately secure drawback, it is a document-intensive process. So, you need to make sure that when you are, filing a claim for drawback, you have a significant number of documents that really substantiate your claim. So now that we kind of know what drawback is, let's take a step back and look at the legal architecture surrounding it. And specifically, we'll look at the laws and regulations. There's really one primary law when it comes to duty drawback, and that would be Section 313 of the Tariff Act of 1930 as amended. I know this sounds a little unusual, but I really do want to emphasize for a moment that this is coming from Section 1313 within Title 19 of the U.S. Code. And the reason why I emphasize that is, as we'll see later in the presentation, different types of drawbacks have different names and even different nicknames. But another common way for practitioners to just kind of casually refer to a type of drawback is by citing the subsection within Section 1313 that they are drawing drawback from. So you'll see that sprinkled in throughout the presentation as well. So that's the main statute. In terms of regulations, there are kind of two different types. There's one that applies to general claimants. That would be in Part 190 of the Code of Federal Regulations in Title 19 there, the modernized drawback program. And then there's another regulatory framework for USMCA claimants. I put that on the screen for you, but quite candidly, it's not something that we will be discussing really in today's presentation, because it just doesn't have as much general applicability. And as you can see on the graphic on the left-hand side of the screen, the caretaker of the legal architecture surrounding drawback is U.S. Customs and Border Protection, CBP. So if you recall from earlier, we talked about how drawback is a refund program, the oldest. And we talked about how it was a refund of 99% of duties, taxes, and fees. So specifically, what you see now on the screen are the different payments that are eligible for refund. And some of it I don't think is super surprising, right? Like ordinary customs fees, the duties that you pay on entry or perhaps withdrawal from a bonded warehouse. Some other notable fees include merchandise processing fees, harbor maintenance fees. So that's what's eligible for refund. What's ineligible for refund, however, are certain trade remedy duties, anti-dumping and countervailing duties, as well as over-quota duties paid on certain agricultural products. And it is these types of payments that you see explicitly mentioned in both the statute and the regulations governing drawback. However, as these days, we're all kind of concerned about what I'll call maybe policy tariffs, additional applicable tariffs on top of these, what we might think of as ordinary duties, fees, and taxes. So I highlight those for you as well. So just kind of jumping back to the payments that are eligible for refund. Section 201 tariffs, safeguard tariffs are eligible for refund. Section 301 tariffs currently applying just to goods from China, although if you wait a few weeks, Nicaragua too, and maybe in a year's time, Brazil. And then also the reciprocal tariffs, which have been established under the International Emergency Economic Powers Act, or IEPA. Those are eligible for refund. What's not eligible for refund, though, are predominantly the Section 232 tariffs, as well as the IEPA fentanyl tariffs, which impact Canada, China, and Mexico. But one trend that we are seeing increasingly is that there are certain carve-outs for different Section 232 tariffs where either drawback or certain types of drawback are in fact available for refund. So one thing that so that's kind of what you're hoping to get back by filing a drawback claim. Now, one thing that I want to do before we actually talk about the different types of drawback is talk about quirks that apply to all types of drawback. And for that, it's probably easiest to return back to our definition. And specifically, the two quirks surround two of the most prominent verbs in this definition, which is exportation and destruction. And the reason why they're quirky, if you will, is they take on a meaning kind of beyond how we normally use them in ordinary parlance, because they are, after all, legal terms of art. So let's start with exportation. When we talk about exportation, ordinarily, we think of a shipment of goods that leaves the United States. And I do use the word shipment, not sale, because something that can be exported doesn't necessarily need to be a shipment. For example, you could send samples abroad, you could send gifts abroad. So I purposely use that word. That's how we normally use the word exportation. But for drawback purposes, an exportation could also include simply sending goods to a foreign trade zone in zone restricted status, as well as goods laden onto qualifying aircraft or vessels under a specific statute. That one's not as common. But just to kind of go to the first type of exportation that you wouldn't ordinarily think, that's an example where there are foreign trade zones in the United States. So the good itself is not necessarily leaving the United States, but for the purposes of drawback, that does constitute an exportation. So that's kind of the first quirk. The second quirk, as we alluded to earlier, or stated earlier, was destruction. Ordinarily when we think something has been destroyed, we think, oh, it must no longer have commercial value. However, in the world of drawback does provide for this concept of valuable waste, or just simply waste for short. And that is a reference to material or materials that have been recovered from the destruction process, either of the imported merchandise or the manufacture or production of an article that's used imported or substituted merchandise. Now, of course, when you recover waste, the value of that recovered waste, those recovered materials, is ultimately going to be deducted from the claimant's drawback amount. But just keep in mind that when we think of destruction, it's not just the complete obliteration of an item to the point where it's rendered obsolete. So that applies to all types of drawback. I think with that, we should turn to specific types of drawback that are available to the trading community. Now, there are a wide variety of different types of drawback. For example, meats cured with imported salt. So if imported salt is used to cure fish, the duties on that salt can be remitted. If a product is manufactured with domestic alcohol and then exported, a drawback of the internal revenue taxes paid on that domestic alcohol can be remitted. So there are different types, but as Samir pointed out in today's agenda, we're really going to focus on the three most common types of drawback that the trading community exercises: rejected, unused, and manufacturing. And we are going to talk about them in that order. I think ordinarily when people talk about drawback, they go through it through the actual statute, and they just go A to Z, 1313A all the way down to 1313Z, and they just talk about it sequentially. What we're going to try and do today is we're going to try and talk about kind of how we view drawback from its most simplistic version all the way to a more complex version, which is manufacturing. And the reason we're going to do that is hopefully by the time we get to manufacturing, you have a much clearer sense and understanding as to what exactly drawback is, because drawback is the most complex area of customs law. And that's not me talking. That's actually U.S. Border and Customs, U.S. Border Customs Protection. CBP is on the record as saying that because this type of customs law touches on both the importation and the exportation process, it is the most complex area. And it's no surprise that for drawback claimants or prospective drawback claimants, they're frequently communicating with specialists, drawback specialists in particular, in terms of identifying if they have a claim and then navigating that process if they do. That was a lot right there. Let's jump into rejected merchandise. So rejected merchandise drawback, sometimes known as 1313C drawback, is claimed for certain imported merchandise that I myself like to casually refer to as merchandise. So this is merchandise that does not necessarily conform to sample or specifications. It may have been shipped without the consent of the consignee. It could have been determined to be defective at the time of its importation, or it was sold at retail, but for whatever reason, it's been returned by the customer. That's all eligible under 1313C drawback for a 99% refund of the duties, taxes, and fee that was paid on that imported merchandise, which is fantastic. But there is one really prominent condition that we need to highlight, which is that imported merchandise, which I could have on the screen just simply written as that rejected merchandise, it has to be exported or destroyed within 5 years from the imported merchandise's date of importation. Now, another way of looking at rejected merchandise is rejected merchandise on its own is effectively not used. So there is a very nice way of, another way of putting this is all rejected merchandise is unused merchandise, right? Not all unused merchandise is necessarily rejected, but what's helpful about this is that this slide really aims to illustrate that unused merchandise drawback can be applicable, can be claimed for rejected merchandise to the extent that the rejected merchandise satisfies those requirements as well. That's important from a compliance standpoint. We'll see that later in the protestation process. So just bear in mind, if you have rejected merchandise, you might also be able to use the unused merchandise drawback scheme instead if preferential and applicable. But we've been talking a lot now about unused merchandise, so let's jump ahead and talk about what that is. So unused merchandise, as kind of the name suggests, also known as 1313J1 drawback, is claimed on imported merchandise that has not been used in the United States prior to its exportation or destruction. And you might be wondering, does that mean it can't be touched whatsoever? And the answer is no. There are 17 different incidental operations that are acceptable because they're really not going to change the character of the merchandise. I suppose you could say there are 18 if you want to say, or any combination thereof. But, simply repacking that merchandise, cleaning it, sorting it, that's not really effectuating a meaningful change to the merchandise. So it still stays in this unused status. The catch, though, and we'll see this theme throughout, we've already seen this with rejected merchandise drawback, is that the imported unused merchandise has to be exported or destroyed within 5 years from the imported merchandise's date of importation. And to be clear, although this unused merchandise is not directly used in the manufacturing of an article, because we are looking at it directly, that is the direct claim for the drawback. This type of drawback is also known as direct identification unused merchandise drawback. It's kind of a mouthful. It's a lot easier to say 1313J1 drawback for sure. But you can see how there are different names that apply to different types of drawback, which kind of makes this yet even more complex, but much to our frustration. But interestingly enough, there's actually a second type of unused merchandise drawback that the trading community can leverage, and that is 1313J2 drawback. And here, same conditions apply as before, right? The merchandise hasn't been used and won't be used prior to its exportation or destruction. And again, it's been exported or destroyed within 5 years from the date of importation. Here's the difference, though. The difference is that this is claimed on merchandise, whether obtained via importation or even sourced domestically, that is classified under the same 8-digit tariff code within the Harmonized Tariff Schedule of the United States, HTSUS, as the imported merchandise that would have been claimed for drawback. You're effectively then, when you think about it, you are substituting another type of, admittedly a very similar type, but yet another type of merchandise for the imported merchandise's place. And as a result, this type of unused merchandise drawback is also known as substitution unused merchandise drawback. So yet another way to refer to 1313J2 drawback. I know that gets confusing, but because you're not using the imported merchandise directly, because you are using substituted merchandise, there are some pretty prominent limitations put in place. And there are two in particular that I want to highlight for you today. The first is the other rule, which is more commonly known as the 8-digit rule, because it's just incredibly difficult to say to someone, hey, did you hear about the other rule, or do you know about the other rule, without knowing specifically what you're referring to. And then the second is the lesser of rule. So let's take these in turns. Let's start with the 8-digit rule. What the 8-digit rule stipulates is that J2 drawback is actually precluded when the merchandise description at the 8-digit level of an HTSUS subheading begins with the term other. So to reiterate, if at the 8-digit level, the article description or merchandise description starts with the term other, you can't actually exercise J2 drawback. However, there's a little caveat here. If the breakout text starts with the word other of the imported or substituted merchandise, as well as the exported or destroyed merchandise, but the text is still identical. It actually, they share the same 10-digit tariff classification, and the text is identical and the breakout text at the 10-digit level does not begin with the term other, then you can still use J2 drawback. So I feel like communicating that is quite challenging in the sense that, I'm a visual learner. It really helps to look at the tariff schedule. So full disclosure, when I was drafting these slides, I was extremely hungry and I was actually eating a piece of toast with jam. And I was really curious about how I could somehow use this for my presentation. And it turns out you can. So I found the tariff code. I was having peach jam So here is the tariff provision. Now, specifically, these are preserved nectarines and preserved peaches in cans. Now here, let's just assume for the sake of argument that I have domestically sourced a bunch of nectarines and I put them in my warehouse and I've got them there. And then I also import a whole bunch of other types of peaches, canned peaches, and I put them in my warehouse and I want to export the other peaches. And I do want to export the other peaches. And I think to myself, oh, I can use the nectarines for substitution unused drawback, right? Now, you would be precluded from doing so because, as you can see, nectarines and other peaches do not share the same 8-digit level description. So J2 drawback is precluded in that sense, right? But for the sake of argument, if they also don't forget too that the 8-digit level for other peaches starts with the term other. So J2 drawback is not available here. But this is a good example of how that kind of carve out with the 10-digit level could actually apply. So again, let's say now that I domestically source cans of other peaches, right? I'm going to put that in my warehouse. And let's say that these cans are less than 1.4 kilograms. And then I'm also going to import a bunch of canned peaches, also in containers less than 1.4 kilograms. And then I'm going to export my domestically sourced versions, right? Initially, you would think, oh, well, you can't do that because the 8-digit rule stipulates that at the 8-digit level, the text starts with the term other, which is true. But again, if what we're substituting and importing and exporting, if it shares the same 10-digit tariff classification and the description does not start with the word other, like right here, then suddenly J2 drawback is permissible. I know it's highly technical. It takes a while to kind of grasp all of that, but that is what the 8-digit rule ultimately allows for. So it's an exception, it's a requirement, and then there's an exception layered with another exception on top of that to keep in mind. That's the first limitation that we talked about. The second, if you recall, was the lesser of rule. Fortunately, it's a lot more simple to grasp. The lesser of rule is pretty straightforward in that what you do is first you imagine that the substituted merchandise was imported, in which case it incurred duties, taxes, and fees. And then to calculate your J2 drawback amount, what you'll do is you take the lesser of the amount that either would have been paid or was actually paid on that substituted merchandise, or the amount applicable to the imported merchandise that the substituted merchandise is replacing. So to state that differently, you're only getting refunded the smaller of the two duty amounts, which prevents over refunds when substituted goods are used. That was unused drawback. Let's shift over to the third and final most common type of drawback that the trading community uses, which is manufacturing drawback, also known as 1313A drawback. Manufacturing drawback applies, well, it's claimed, I should say, for imported merchandise that is used in the manufacture or production of an article in the United States that is subsequently exported or destroyed. But that article, first of all, cannot have been used in the United States prior to its exportation or destruction. It must be exported, and it must be exported or destroyed within 5 years from the imported merchandise's date of importation. Now, because we are tracking the imported merchandise directly here, not substituted merchandise, this type of manufacturing drawback, 1313A, is sometimes also known as direct identification manufacturing drawback. Now, some of you out there are probably thinking, okay, well, we talked about what it means to be used and unused. What exactly do you mean by in the manufacture or production of an article? What exactly does that phrase mean? And specifically, what that means is that for merchandise used or appearing in the manufacture or production of an article, that article has been made into a new and different article, as indicated by having a new and distinct name, character, or use. For those of you out there that are familiar with the substantial transformation test, that is more or less kind of the standard that's being applied here. Now, similarly, a merchandise in the manufacture production of an article could mean that it was processed for a particular purpose or function, even though it might not necessarily have a new and distinct name, character, or use. So that is what in the manufacture or production means. Now, there is another type, though, of manufacturing drawback that I want to bring to your attention, and that is 1313B drawback. Again, same conditions are going to apply as before, right? It's going to be claimed on merchandise used in the manufacture production of an article in the United States, subsequently exported or destroyed. We know that that article cannot have been used in the United States prior to its exportation or destruction. And finally, that article has to be exported or destroyed within 5 years from the date of importation. So where's the difference? This time, the difference is that this can be claimed on merchandise, whether obtained via importation or sourced domestically, that is classified under the same 8-digit tariff classification as the imported merchandise that would have been claimed for drawback. Now, some of you out there are probably thinking, oh, that's actually really similar to substitution, unused drawback. And you'd be completely right. 1313B drawback is also known as substitution manufacturing. So that is, in a nutshell, what manufacturing drawback is, but kind of like unused drawback, where we discussed two major limitations, the 8-digit rule and the lesser of rule. Manufacturing drawback also has certain limitations as well. And the two that I want to highlight for you are having a manufacturing ruling and the lesser of rule. I'm not going to describe the lesser of rule because we've already discussed what that is. So let's focus on a manufacturing ruling. So to claim manufacturing drawback, the claimant must have a manufacturing ruling to point to. And you might be thinking, well, where exactly should I find such a manufacturing ruling? And the answer is in the regulations. In the regulations, there are several generally applicable manufacturing rulings. And if you were to identify one that applies for you, then you would send CBP a letter of notification of intent to operate under that general manufacturing drawback ruling. And if satisfied, CBP in turn will send to you a letter of acknowledgement that authorizes you as the manufacturer to operate thereunder without variation. Now, these general manufacturing rulings might not necessarily apply to you. There's a good chance that they do, but there's an off chance that they might. And if that's the case, then you could alternatively apply for a specific manufacturing ruling to CBP. But fair warning, that is an extremely time-intensive process. It typically takes more than a year for a specific manufacturing ruling to be reviewed. I've seen it typically be as late as 2 years, so it is quite a kind of a time-intensive process. But the good news is that if you are interested in pursuing this path, there are sample-specific manufacturing ruling applications. I didn't list it on the screen, but it would be in Appendix B to Part 190 of Title 19 within the Code of Federal Regulations. But one thing that kind of this is alluding to is we're talking about manufacturing rulings, we're talking about letters of notification of an intent to operate under them, letters of acknowledgement. We're talking about a lot of documents. And as mentioned kind of at the beginning of this presentation, drawback in itself, no matter really what type of drawback you're availing, whether it's manufacturing or otherwise, is a document-intensive process. So with that, let's kind of shift gears and talk about the compliance requirements. And let's just start right where we were, which was record keeping. Generally, all records in connection with the filing of a drawback claim have to be retained for 3 years from the date of liquidation of that drawback claim. And the types of documents that you would want to maintain are, for example, entry documents evincing, the quantity and identity of the imported duty paid merchandise. Specific documentation for the type of drawback availed. So for example, with manufacturing drawback, as we were just discussing, a manufacturing ruling. If you use rejected merchandise drawback, then you would want documentary evidence that establishes that the merchandise was rejected, that it did not conform to sample or specification, or it was shipped without the permission or consent of the consignee. Also, your drawback calculations, the proof that your merchandise has in fact been exported or destroyed, and as discussed at the earlier, any quantifiable valuable waste, if there is any. So there are a lot of documents to maintain. This is kind of a very lawyerly comment here. It's a fair warning, but why would you want to keep all of this? Really two reasons, right? One is because it demonstrates good faith compliance with the law, which is great. But also, if need be, if things suddenly go awry, then you have a pretty solid defense where you can either back yourself up or at least try and figure out where the gap is. Those are the types of records that you would definitely want to retain and communicate and convey with CBP. Another type of document that you might not necessarily have to, though, is if you are transferring your right to drawback, because drawback claims, or at least many types of them, I should say, are transferable. And specifically, the assignment of the right to claim drawback can attach either to the imported or substituted merchandise, or the article that has been manufactured or produced from that imported or substituted merchandise. And what you would want if there is some assignment is you'd want some certificate from the assigner, where the assigner is basically saying, look, I am certifying that I have not claimed and will not claim drawback on this export. And similarly, I'm not going to assign that right to another party. So that is a type of record that might not necessarily apply, but if it does apply, you would want to retain that for 3 years after the liquidation of your drawback claim. Now, one record that you absolutely do need to retain that I bring special attention to is CBP Form 7553, also known as a Notice of Intent to Export, Destroy, or Return Merchandise for Purposes of Drawback. What happens is you submit Form 7553 to CBP, and within 2 working days, CBP will notify that party of its decision whether to either waive examination or to examine the merchandise. And if they do so, they'll do so within the next 5 working days. Now, that kind of, I think, naturally begs the question, well, when exactly do you need to file your Form 7553? And the truth is that depends on the type of the type of drawback that you're claiming and the type of activity. So I specifically highlight the ones that we've talked about in this matrix during today's presentation. As you can see, for exportation, if you are availing manufacturing drawback, you actually don't need to give CBP any prior notice when filing the 7553. But if you're filing a claim for rejected merchandise drawback, you would need to give CBP 5 business days advance notice. For destruction, it's, as you can see, straight across the board, 7 business days. So that is what you would need to give CBP as you are about to, go about filing your drawback claim. I think the natural question then becomes, where exactly do I file this drawback claim? And the answer is that you file your drawback claim electronically through CBP's Automated Commercial Environment, or ACE. And what is crucial to note here is drawback has been modernized. It was modernized actually only recently, less than 10 years ago. So a complete drawback claim is timely filed if fully submitted within 5 years after the date the merchandise designated as the basis for the claim was imported. And that is a change that didn't always used to be the case, but as part of this modernization effort, there was a consensus that there should just be a straight 5-year period, a 5-year period to import or substitute merchandise, have that merchandise exported or destroyed, and then to file your claim. And then once you file your claim for drawback, it typically takes about 1 to 3 years to process. And if approved, normally the 99% refund on duties, taxes, and fees is dispersed about 21 days later, about 3 weeks later from the claim's decision date. That is a pretty lengthy amount of time. A lot of you are probably thinking, is there any way I could get my refund sooner rather than later? And the answer is yes. You could apply and if successful, receive accelerated payment. I believe that means that you would get payment roughly like 45 to 60 days after filing the claim. This is a special privilege though, right? You have to apply for it. You have to confirm that you're satisfying all the statutory and regulatory requirements. But clearly the benefit here is that you will receive the eligible duties, taxes, and fees, and it's refunded prior to the final review of drawback claim and liquidation. So we've now been talking about what happens when you file your claim and it's been reviewed. Let's turn a little bit here and look at what happens if you file a claim, but it's been denied. If you have been denied your claim for drawback, one piece of advice we always give is, well, hey, before you submit that protest, just make sure that another subsection within section 1313 doesn't apply. Because there is a rule that if a claim for drawback isn't allowed under one provision, but it is allowed under another provision within section 1313, then you could rely on that alternative provision instead. Of course, you would need to, demonstrate that you've satisfied the requirements of that other drawback provision. But that can be really useful, kind of as we talked about earlier, about how, like we mentioned, all types of rejected merchandise is unused, but not all unused is rejected, right? If you have a rejected merchandise drawback claim and it gets denied, it might be worthwhile to pivot and see if you can still pursue a drawback claim, but this time under an unused drawback claim instead. So we always just kind of try and remind people to look at that, that audible, if you will. But if that is not applicable and your drawback claim has in fact been denied, then what you can do instead is you can contest it by filing a protest within 100 days, 80 days after notice of liquidation of the drawback entry. And if necessary, if you need to escalate this even further, then what you could do is you could file suit at the U.S. Court of International Trade in New York. So those are kind of the main compliance requirements. Now let's shift gears a little bit and talk about penalties under drawback. So specifically, there is a specific statute for false drawback claims. It is section 1593A within Title 19 of the U.S. Code. And there are maximum civil penalties that apply, but they actually do depend on the level of culpability. There are two identified: negligence and fraud. And as you can see in the developing matrix on the screen, depending on the frequency of your violation, there is a difference in what the maximum civil penalty is, but it is going to be tied ultimately to the actual or potential loss of revenue. And if you're curious what I mean by loss of revenue, what I'm referencing there is the drawback of duty that should not have been paid or credited. So if it's your first violation, but you were merely negligent, then it is a 20% amount of the actual or potential loss of revenue. Your second violation, going to be more than double. It's going to be 50% of the actual or potential loss of revenue. And for your third or more, your successive violations, 100% of the actual or potential loss of revenue. Fraud's a little bit of a different animal. Fraud obviously has a connotation of an intentional deceit. So in those situations, Section 1593A applies a maximum civil penalty of 3 times the actual or potential loss of revenue. Now, some of you out there might be thinking to yourselves, well, hold on. I thought that Section 1592 was the general customs fraud statute. Shouldn't that apply instead? And you're not wrong. Section 1592 is that, right? It identifies actually 3 levels of culpability: negligence, gross negligence, or fraud, by means of a false statement, right? That's resulted in merchandise entering or attempted to be entered into the United States, right? 1593A, though, is a specialized fraud statute dealing exclusively with drawback claims. So in that instance, it will displace the application of Section 1592 when the misconduct is relating solely to a drawback claim. Now, some of you out there might be wondering, well, wait a minute. is there ever a situation then where Section 1592 and Section 1593A can apply concurrently? And the answer is, perhaps horrifyingly, yes. While Section 1592 focuses on the entry, at fraud at the entry stage, so think of maybe fraudulent misstatements that affect the valuation of the merchandise, its origin, its classification within the tariff schedule, right? If that fraud informs a drawback claim, that drawback claim is effectively tainted now, right? It's a fraudulent drawback claim. And in that situation, both statutes can apply. Of course, the penalties, though, would be separately tied to the distinct underlying fraud, where 1592 is applying to the fraud at the time of entry, and Section 1593A is applying to the drawback fraud in particular. Now, these are all, we're talking about penalties. Clearly, they're quite painful. Some of you might be wondering, was there any way I could possibly mitigate my penalties? And the answer is yes. You can submit a prior disclosure to CBP prior to CBP commencing a formal investigation in an attempt to mitigate your penalties. And in doing so, by submitting a prior disclosure, your penalties can be mitigated depending on the level of culpability involved, the standard. So if it's negligence, then you'll still be penalized, but you'll only be penalized on the interest of the actual loss of revenue. Whereas if it's fraud, then it would be 100% of the actual or potential loss of revenue. One thing that we like to remind people, though, is that if you are going to pursue a prior disclosure, because CBP has yet to commence a formal investigation, and you suspect penalties are on the horizon, but you want to mitigate them, we always just simply remind individuals or organizations who pursue a prior disclosure that they'll have to tender the overpaid drawback claim that they received at either the time of submitting their prior disclosure, or at least they'll need to be prepared to do so within the next 30 days after submitting it. So you will have to relinquish that unlawfully obtained funds. So those are the penalties. Just to kind of provide you with kind of how this looks procedurally, though, basically you wouldn't see a penalty unless CBP had reasonable cause to pursue one. That's the legal standard here. If CBP does have reasonable cause, then what they will do is they will send the alleged violator a written pre-penalty notice. Technically, they can actually proceed directly with a penalty claim if the claim itself is less than $1,000 or less. But let's just assume, for the sake of argument, that in this case, it's going to be more than $1,000, right? In that situation, CBP sends a written pre-penalty notice, and the recipient of the pre-penalty notice then has 30 days to effectively contest that. They can contest the penalty claim, and they can contest the amount stated within that penalty claim. But let's just say that CBP is quite keen on pursuing this. They are not interested in canceling the penalty sought. In that instance, after this period has lapsed, CBP will then issue a penalty claim to the alleged violator. I think at this point it probably is the violator. And at that point, the violator will then have 60 days to contest that penalty claim. And at the conclusion of that, that'll lead to a written final determination by CBP. What's kind of awkward about this is, weirdly, CBP can't actually enforce the penalty claim. It actually has to pursue relief by advocating for this administrative penalty to be enforced judicially. So what would end up happening is CBP goes to the Court of International Trade to obtain a judgment to actually collect. So there's a little awkward hiccup. And the CIT technically will review that administrative penalty de novo. So I suppose there is a way out still for this alleged or actual violator, but I wouldn't hold my breath in that circumstance. But what is interesting is that throughout this entire process, interestingly enough, drawback penalties are one of the few types of customs penalties that can be compromised and settled before actual payment. So there is still another avenue kind of lurking in the background of all of this where the violator can perhaps mitigate their penalty. Of course, and finally, a way to mitigate penalties is by having a really robust drawback compliance program. And one way you could do that is not just simply having one, but enrolling in CBP's voluntary program and becoming certified. There's a huge advantage to this, right? While again, very document intensive, the advantage is that in the absence of repeated violations or fraud, then the party that has been certified with a robust drawback compliance program would only be issued a warning letter in lieu of monetary penalties, which is a huge relief. Of course, if there are repeated violations or fraud, then the party in this instance would risk not simply monetary penalties, but also removal from certification until a certain corrective action is taken, and specifically action that is satisfactory to CBP. So with that, it's a lot of information. Again, this is an extremely complicated and complex area of customs law. We are happy to take your questions now. Before we do, though, quick shameless plug here. Here at Thompson Hine, the International Trade Practice Group does have a blog. I would say it is way more active than it ever has been before, given recent developments in the field of trade. So if you haven't already, we highly, highly encourage you to subscribe and to receive weekly email notifications about when blogs are posted, and in turn, kind of staying up to date and informed about how this is affecting you. And again, just to really draw it home, we see that even with drawback, where certain types of drawback, for example, with Section 232 tariffs, some drawback or some types of drawback are actually available when maybe previously they haven't. So do make sure to subscribe to our blog. And with that, thank you so much for attending today's presentation. Samir, if we have any questions, happy to entertain them.
Yeah, sure. Yeah, I didn't want to stop you because you were in a zone over there, but we do have a couple questions. The first one is, so drawback on auto parts, does that exist now? I thought you couldn't get drawback on auto parts. Do I take that one?
Yes. So whoever asked that question, you were historically correct. Oh, thank you. Yeah. So you historically could not get drawback on on Section 232 tariffs related to autos. However, when Trump authorized manufacturing drawback for MHDVs, for medium and heavy duty vehicles, there was a kind of awkwardly and oddly a provision buried in there that said that you can in fact receive manufacturing drawback available for Section 232 tariffs on automobile parts. So that is quite new, and that is why I've kind of carved it out here on this slide.
Okay, great. The next one was about transferability. So I'll pull up that slide, but the question is, does this mean that I don't have to be the importer in order to be able to take advantage of drawback? How does that work in practice?
Yes, you do not need to be the importer. Someone else could be the importer, and then they transfer the right to drawback to you. I suppose in this case, you're the exporter. So you do not need to be on both ends of the shipment process. That answer the question?
Yeah. It's basically you can partner up. I think the idea of how it works in practice is you partner up with, like an importer partners up with an exporter, and they can do substitution of the goods and basically claim drawback on, in that sense, right?
Yeah.
Okay. Record keeping, there was a question about, isn't the statute of limitations 5 years for import violations? And so I think the question is, I'm just going to that slide, is, must be retained for 3 years. Does that go, I guess, against the statute of limitations period?
So I would say that Yeah, they would appear to be incongruent with one another, but in that case, this is I just want to emphasize this is the minimum number of years that you're required to retain those documents. So in that case, it probably would be a best practice to hold on to them for a longer period of time to make sure that you comply with the statute of limitations.
Yeah, I think that's right. I mean, I think that it's 5 year statute of limitations. Record keeping is a 3 years from the date of liquidation of that drawback claim. Usually that is, already after some of the imports. And so, statute of limitations considerations can vary depending on sort of when the import happened and when the violation happened. But generally speaking, because of that 5 year, and honestly, in this day of digitization and record keeping, most companies are keeping it for a longer period of time than 3 years. But that is the rule under the statute for 3 years. We have another question. Can you receive, and I actually don't know the answer, can you receive drawback on tobacco products?
If I'm not mistaken, I believe you can. My understanding, though, is that is a kind of highly specific type of drawback. So it is not one of the kind of common ones that you would use. You wouldn't go through rejected, unused, or manufacturing. So I believe the answer is yes. You just simply wouldn't go through one of the routes that we've kind of described in detail today.
And I would suggest for the individual, we'll get back to you on that also, because we have another shameless plug. We have a large practice that deals with vaping and other products, and including individuals like Michelle Lee, who do a lot of work on the import side of that equation. And so we can absolutely get back to the person who asked that question for that as well. I do have, I guess we have just a few more minutes, so I might as well, there's another question here. So it was about accelerated payment. Accelerated payment, for those remember, it was noted that you received payment pretty quickly within, I think, 45 days of the drawback claim. Is that correct, Aaron?
Yes, technically that is the floor, not the ceiling. I've seen CBP though kind of really emphasize that that is pretty ambitious. So you shouldn't necessarily assume that you'll have it within 45 days.
Okay. And then the other one is a penalty. When you had mentioned penalty claims, can you still claim a prior disclosure for products that are subject to a penalty claim?
I would think not, because a penalty claim wouldn't arise unless CBP had commenced a formal investigation, and upon that occurring, the option of pursuing the prior disclosure route is foreclosed.
Yeah, I think that's right. I mean, I think it's not. You can still claim disclosure on all similarly situated goods, likely, if the penalty claim is really specific to one, or not one, but a subset of drawback claims or something like that. If you find that is actually more consistent, if you have that sort of violation that's more consistent throughout your imports or exports or drawbacks, you can probably claim prior disclosure on those other ones, which would be a good idea. So I see that we're at the end of our time. Again, thank you all for joining today. Thank you, Aaron, for running through the presentation. All subscribers will receive a copy of the presentation. All attendees, I should say, will receive a copy of the presentation. If you're seeking CLE codes, if you're seeking CLE today for the program, today's tracking code is TH2014. Again, the tracking code is TH2014. Thank you all for attending and joining. As I noted at the outset, this is the fourth in our series. We have one more Coming up, our final session will be held on December 3rd at 2 p.m. that will discuss Chapter 98 of the HTS schedule. For those of you who are aware, Chapter 98 offers a number of different duty saving provisions for imports and some exports that allow you to, it's another tariff mitigation strategy. It's one that we've seen being used very frequently recently. And so I urge you all to attend. Thank you all for attending this webinar. Enjoy the rest of your day. Be well. And, a week in advance, happy Thanksgiving.